Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1108 et al. Green Development LLC petitioner versus Federal Energy Regulatory Commission. Mr. Bustami for the petitioner, Mr. Esty for the respondent, Ms. Almeida for the intervener.
Mr. Bustami, good morning. I don't know if we should call you the relief advocate or not. I know you're here on very short notice.
Thank you very much. Good morning, Your Honors. Omar Bustami for the petitioner, Green Development LLC. I've respectfully requested 2 minutes of my time to be reserved for rebuttal. Your Honors, the filed rate doctrine prohibits utilities from charging any other rate than that which is on file with the Commission. It has been described as a nearly impenetrable shield, preventing discriminatory and extortionate pricing. Here, Your Honors, that filed rate is the ISO New England tariff, and that tariff includes several key requirements that the Commission ignored when it approved a plan among two affiliated entities to generate over $18 million in new revenue through an improper direct assignment facility charge. Respectfully, this court should vacate and remand FERC's orders for numerous independent reasons. First, as I've mentioned, there is the filed rate issue. Second, Your Honors, the Commission also failed to properly evaluate whether the filing parties met their statutory burden under FPA Section 206 to demonstrate that the charge is just and reasonable. And finally, Your Honors, the Commission failed to evaluate the totality of the circumstances with respect to each of the Commission's 7 factors that the Commission is supposed to use to evaluate whether certain facilities are FERC jurisdictional transmission facilities or whether they are state jurisdictional distribution facilities.
This isn't really a filed rate issue. There's no dispute that they have to allocate costs according to the tariff. The question is just what the tariff means, right?
Your Honor, I would respectfully disagree with the contention that this is not a filed rate issue because the entire tariff is considered essentially to be, as a matter of law, a filed rate. So
Sure, but there's just a question about what the word requesting means.
Yes, Your Honor, but that word requesting, as petitioner contends, is key here to determining whether the charge is appropriate. If I may, Your Honor, I will address some of the key components of the definition that enable that charge to be assessed or not. Principally, there are 2 essential file rate issues that focus on 2 parts of the tariff. First, you have the definition of direct assignment facility. FERC erred by classifying these facilities as direct assignment facilities and as such permitting the charge to be assessed on the transmission customer in Narragansett. That's the first error that FERC made by not following the definition of direct assignment facility. And the second key part—
So wait, on that, you're saying that because they misread requesting service, that, and how does that make the direct assignment facility determination invalid? It's basically, if they had done that, then they would have pinpointed a time when the need for the facility arose, and they would have done a study that would have assessed who benefited from it, and they didn't do any of that, in your view? Or just give us a more practical, on-the-ground understanding of what flows from your argument about the term requesting.
Certainly, Your Honor. That's your description in petitioner's view is correct. So that provision establishes not only the basis for the charge, but establishes 2 things, essentially, that the charges are going to one particular customer as opposed to being allocated across the board. And then, but second, more importantly, it establishes that there has to be a nexus between the transmission request and the upgraded issue. And the definition explains that the charges are to be assessed on the transmission customer too. So it's a little bit more than your ordinary definition. It actually sets forth a lot of different provisions that have to be followed. It sets forth the basis of the charge. And so that principle in and of itself and that definition in Green Development's view is an independent basis on which FERC erred. However, you also have the process.
Just to stick on that for a moment. So in arguing about the direct assignment facilities definition, are you disputing that the upgraded facilities would be for Narragansett's sole use or benefit? You're not disputing that.
Well, Your Honor, Green Development doesn't believe that there's any evidence in the record to show that these are needed for a transmission purpose for Narragansett. However, even assuming arguendo that they are needed for Narragansett, that doesn't permit the agency to act contrary to the filed rate. It still has to evaluate the filing party's burden, and it has to evaluate whether the definition is correctly adhered to in order to permit the charge. So what we believe you have here, and the respondents have sort of teed it up as sort of a cost causation argument, but really whenever the cost causation principle, which is really this idea that if someone benefits from something, they have to pay for it. So here that beneficiary theoretically is Narragansett, the transmission customer, not Green Development. That essentially this has to be allowed because Narragansett somehow benefits or needs this for transmission. But whenever that principle comes into tension with the filed rate prevails. The filed rate doctrine doesn't allow the agency to waive the operative provisions of the tariff to allow charges to be assessed after the fact. If the filing parties wanted to assess charges in that way, they would have to file something with the commission that allows that to happen first. So it really is a notice principle to put the ratepayers on notice of what's permitted to be passed through and flowed through, and sort of transitioning to the kind of second key part of the tariff, which is Schedule 21 local service. We think that provides more confirmation of this understanding, because you basically have four key parts of that rate schedule that the filing parties have to demonstrate were met. So first you have the preamble of that provision, which basically requires that all transmission customers taking service are subject to those terms and conditions. Next, you turn to, and if you need a specific reference, I can certainly provide it to you, but it's, I believe it's section 2 of Schedule 21, LS Section 2, Part 4. So what is essentially laid out there is a very clear process by which whenever the transmission owner wants to, and customer in this case, wants to amend what's referred to as the local service agreement, they have to file a request for transmission service. So that's key here, because that's what happened in December of 2021. The filing parties came in and they amended their local service agreement. So you have that provision in Schedule 21 that requires a transmission service request as a condition precedent for the amendment to the local service agreement. And so then what happens is the ball shifts to ISO New England in order to evaluate whether or not a system impact study is needed. Now, it's true that ISO New England gets to decide whether a system impact study is needed, but the proverbial ball that puts that in ISO New England's court is the transmission service request. So that didn't happen here, and we see no evidence in the record that there was ever a transmission service request in connection with these particular upgrades. And so because of that, the ISO didn't really get to, or actually did not get to evaluate at all whether or not these upgrades are needed to accommodate Narragansett's request for additional service. And I would like to direct your honors to what we think is important as part of evaluating the text, purpose, structure, and history of the tariff, because the definition of direct assignment facilities really derives from a rulemaking in the 90s called Order 888. It's been described as the bedrock of electric utility regulation by this court. So that order actually goes into an explanation about why the commission allows specific transmission upgrades to be assessed and charged to one particular transmission customer as opposed to being broadly allocated. And what the commission says is that it really has to do with that customer's need for additional transmission service over what the transmission customer is already receiving. So in other words, transmission customer is getting general service, but then it wants a little bit more. So it makes sense that if it, by that request, causes the need for an extra upgrade, that transmission customer has to pay for that extra upgrade. The commission is very clear about this. In principle and according to the filed rate, green development prevails on both aspects, but in any event, the filed rate doctrine must prevail.
You think it's genuinely disputed that these upgrades were at the request of Narragansett for Narragansett's benefit, as opposed to, I don't know, Boston Gas or New Hampshire Gas or whoever?
Yes, Your Honor, we do think that is genuinely disputed. And Your Honor, I see that I'm approaching the end of my time. If I may proceed to answer your question. A little bit of what might be helpful to color the situation is to understand that green development uses, to the extent these facilities are needed at all, or any part of them are needed, they would be used in order to deliver power to Narragansett's customers on the distribution grid. So the question here isn't really just, does Narragansett need the upgrades? The question is, does Narragansett need them for a transmission purpose? And Narragansett does not need these for a transmission purpose, and there's nothing in the record to indicate that they do need them for a transmission purpose. Instead, what's happening is that green development's already paying for these upgrades under the state distribution interconnection agreement. And now, because of these duplicative charges, green development is being essentially assessed a duplicative charge. And that's exactly what the filed rate doctrine is intended to protect against, discriminate, extortionate pricing.
I have a question about sort of just really stepping back and in a very kind of real world, practical, layperson's way. Can you describe how Green Development's project relates to the Iron Mine Hill substation? I mean, it seems to me that FERC and New England Power are relying heavily on the notion that the substation is connected to a 115 kilovolt line. And it's sort of, that's transmission, end of story. And, there's a question whether that's the right analysis given the 7-factor test, but be that as it may, what is, and your narrative is kind of like, no, we only ever were getting involved with Narragansett for distribution, we're generating power that's supposed to be used within the distribution system. And it's like this, sort of weird formality that we end up getting sucked into FERC jurisdictional land. And I guess I'd like to understand more the layout and how you have an argument that green development is not actually in transmission land, if you will.
Your Honor, that's precisely correct. Green development is not in transmission land. So, and not to get into too much of the technical aspect, because we understand that's not what the court's job is to go in and evaluate technical questions. It's really for the agency to understand that. But what's practically going on here is green development is essentially building projects on the distribution system. So you'll hear this term distributed generation. So what green development, basically understands that to mean, distributed generation means generation that's essentially produced and used on the distribution grid. So it's not in transmission land. So what happens is that green development goes to Narragansett and, wants these the actual generation projects, not the wires and the equipment that are at issue here. They want the generation projects to be studied, and Narragansett comes back and basically tells them, well, this is what you need to do to upgrade, the wires on the system in order to facilitate your distribution. And in this case, what Narragansett actually did is they gave green development 2 options, and green development didn't know that either option was going to entail a transmission charge. So from the get-go, green development didn't know that. At the 11th hour, they find out that there's transmission charges, but it's really too late. So they have to sorry, go ahead.
I'm listening, go ahead.
So how does green development end up in transmission land? That's really a question.
So was there an option that wasn't taken that would have clearly been slower and maybe more expensive, but would have avoided Narragansett pulling green development into a transmission system?
So green development's intentions, yes, and that is correct. However, even if that green development needs an opportunity to properly understand whether that's true or not. So if there really was another option where transmission wasn't needed, then green development, theoretically would have picked that option if it knew it was going to lead to all these duplicative charges.
Under the circumstance in the case, is it sort of as a matter of understanding the scenario to which one applies the 7 factors? Is it the case that under, given the substation that was built, that effectively green development's power is being put out into, the regional transmission system, and, it's anybody's guess whether some of it is being used for distribution to Narragansett's distribution system, or is it sort of, nominally going there for a moment and then being stepped down and brought back?
No, Your Honor. The power is not being used on the transmission system. Under the 7-factor analysis, it's not a bright line test. So I think
know that, and I'm trying to stay away because I've read and thought through the factors, but what I'm trying to understand is, I don't have a map of how the what is it, H17 relates to the distribution system. Do we have that in the record?
Your Honor, yes, we do have that in the record. And there is actually a sketch in the record, and if you permit me, I can refer you to that.
Okay.
I'd like to answer your question, however.
Is that the one on JA 67? Because I have a question about that.
Right, that shows the H17, but doesn't really show the what is it called, the tie?
Your Honor, that is the schematic that I was referring to, yes.
Right. So below the Iron Mine Hill, am I correct, is the feeder that is not part of FERC jurisdiction, and below that is where Green Development has the solar project?
Correct.
All right. My question is, where is Narragansett in all of this, in this schematic? Because the West Farnham number 17, the Farnham number 105, isn't that all New England Power?
So, Your Honor, if you're looking at this schematic and you see this West Farnham station and you look to the right, that is Narragansett's distribution system in Green Development's contention.
Okay, that's Narragansett. That's not New England Power.
That's that's being utilized in order to move power on the distribution grid to serve Narragansett's retail load. And the only instance in which power could ever reach the transmission grid in this case is if there's a power overload. So, Your Honor, Judge Pillard, you'd mentioned the 7-factor test, so not to walk through that, but we know that one of the tests is to look at the proximity to retail load, and that's evaluated through the purpose and the customer served. So what what the commission found is that because the facilities weren't connected to retail load directly, that they fail that test. These therefore are transmission facilities, but that's not what the test asks for. And FERC's order actually concedes the point that the facilities are used to serve Narragansett's retail customers, which are the customers on Narragansett's distribution system.
So you said to the right, so where is the tie to the retail load? Where do we start to step down from 115 kilovolts to the distribution level voltage? It's not depicted here. I'm just wondering where that happens. I mean, I'm sort of thinking about this. This is, I'm sure pretty crude, but where the highway comes in and it ends, and then you spill out onto Mass Ave, right by the, under the tax court. And, if we have transmission and distribution, the local streets are akin to distribution, the highways are akin to transmission, but where you have, a highway that is coming in and interfacing with the local streets, it seems like, is that analogous to the situation here where just because the slowdown light was put on the last bit of the highway versus, further on at the intersection? I'm just trying to visualize, because I think it's actually important for application of the jurisdictional test.
And I think in that analogy, and apologies if it is a crude analogy on my end as well, but I think the best way to look at it from that standpoint is that you really have a distribution. The distribution is your surface road. That's not the highway. and you have the primary purpose of this road is just a surface road, not a highway. But let's say that surface road gets congested, then you might have cops directing some of the cars to get back on the freeway to make way for other cars, or to use the freeway as a bypass, essentially. So the primary purpose is not transmission. It's really just sort of a backup purpose, and the electrons will rarely, if ever, flow out.
But where is in? You said they rarely flow out, meaning out of the distribution.
Out of the distribution system.
Where is the distribution system on this graphic? That's what I'm not understanding, because, I mean, FERC is basically saying H17, that's a transmission line. This facility, Iron Mine Hill, that's right on a transmission line, right? And I mean, really, their analysis of the 7 factors seems to collapse into, hey, 115. And I'm trying to understand your comeback to that. It's like, yeah, maybe 115, but this is in a distribution setting, and I don't see the distribution setting or understand really where it is.
So in large portion, I think the reason that is from this particular schematic is because the distribution system is somewhat invisible here in whole, because this is really just focusing on the point of interconnection.
Exactly. But in order to apply the 7 factors, don't we need to know at least how the point of interconnection relates to the distribution system?
Yes, Your Honor, we think that it doesn't solely rest on necessarily this schematic. There's more information in the record.
But I'm asking you to sort of, using what you know about the other information in the record, sort of sketch for us what would be shown to better explain that to us.
Sure, Your Honors. So what would be shown here is essentially you would have the generation facilities shown depicted, and then you would essentially
Where are they in relation to Iron Hill Mine? Do they feed directly into Iron Hill Mine? Are they above or below Iron Hill Mine? Do we know? I mean, when we're talking about proximity and we're talking about direction of flow and all that.
So the generation facilities are below Iron Hill Mine.
Below meaning
to the right of, over here on the schematic.
As is the residential users or the retail users?
Exactly.
All right.
And Your Honor, if you permit me to be able to respond to that on rebuttal, I may as well.
Are you finished? Okay. All right. We'll give you a couple of minutes in rebuttal.
Sure. Thank you, Your Honor.
Mm-hmm. Mr. Estes? Good morning.
Good morning, Your Honors. I'm Matt Estes here on behalf of the Federal Energy Regulatory Commission. I'd like to go to the questions Judge Pillard was asking, because I'm afraid Mr. Bastami was mistaken. What's going on here is these 4 solar projects are relatively large. And so if they were delivered to the distribution system at all, there would be a thermal problem causing those lines to melt. So what ended up being proposed, the option that Green Development accepted, was to construct first a 1.5 mile distribution feeder that was of sufficient voltage that it could take this power. And then that delivers that power to the new Iron Hill substation, where it flows onto the transmission system and then is taken off the other points of delivery on the Narragansett system, where it's
to the right.
Yes. And so I was trying to look for this where I could explain how this was the case during this discussion. I couldn't find it. I can write a letter, but at one point in the description of the new facilities, it says that there's no load connected to the new circuit they're constructing. And what that means is that none of the power is taken off of the distribution feeder or to serve distribution load in that area. It all goes to the Iron Hill substation, where it then goes onto the transmission system and is taken off at other points to serve retail load.
But there's nothing in the record suggesting that green development's power would not be ordinarily fully used within this distribution system.
Well, no, there is, because it's not even connected to the neighboring distribution
I understand it's not
system.
directly connected, but were we to think, I mean, well, let me back up. It sounds like, as I was saying to opposing counsel, that in FERC's analysis of whether this is a FERC jurisdictional project, basically the thing that matters is whether this goes on to H17 or not. And that's really it.
Well, that's the most important point, but I think if you go through the 7 factors, you get to the same place.
We can talk about that, but there isn't a regular scenario in which the power is flowing to the region or elsewhere. Just this power that green development is.
I'm sorry, I don't know, you mean the region? Do you mean the area where the solar facilities are located?
No, out to other towns and cities, and as opposed to this distribution.
No, the whole point of it is for the power to flow through the transmission lines, the local lines, and then back onto Narragansett's system.
Distribution.
Yes, that's correct, but not at that location, at other locations.
So you say that if it weren't Narragansett paying as a solar facility, then the cost would be unfairly shared among either Narragansett's retail customers in the event that we were to hold this not FERC jurisdictional, or other transmission customers that don't benefit from these upgrades. But I'm a little unclear, because I thought that green development was already responsible under its state level tariff for paying for operations and maintenance. And so I'm trying to understand what the separate costs even stand for, and whether there's anything to green development's argument that this is double charging.
Well, the commission didn't address that because the commission's statutory duty is to have just and reasonable transmission rates. So in its view, it would not be just and reasonable to assign this cost to any other transmission customers.
But if this cost were already being paid, I mean, it's a little bit like, your state and federal taxes. If you're already paying something in your state taxes and you get a credit at the federal level, if green development is right, that these exact upkeep or maintenance costs are being paid under the state tariff, then is there anybody else that would have to pay them? Were they to prevail either under the tariff or on their jurisdictional argument?
My understanding, but this isn't something the commission found, but my understanding is there are some, if this was deemed not to be a direct assignment facility, but there are some operations and maintenance costs that wouldn't flow to green development under the interconnection agreement that would be paid by other transmission customers. Now, I would just point out on the whole duplicative charge claim that green development filed a case before the Rhode Island Commission making that claim. It's ongoing. And I would think that if, in fact, duplicative charges are they're being subjected to duplicative charges, that the Rhode Island Commission would address that. But that's not the commission's concern. The commission, it'd be arbitrary for them to assign some costs to other customers because they were worried about duplicative charges under the state agreement.
So the commission didn't consider the distribution feeder in its analysis, and it said that was because it wasn't part of the project. But that seems to me potentially anyway, a too narrow understanding of the 7 factors. The 7 factors look at context and often include things that aren't actually part of the project. So it would seem like it's relevant whether the distribution feeder is, confirms the proximity of the ultimate customers and the like. Am I missing something about that analysis?
I think what you're missing is that the commission didn't say that it wasn't part of the project. They were just determining whether the facilities subject to the direct assignment charge were transmission facilities. So if you, whether or not the distribution feeder, which undisputably is a distribution facility, if the 7-factor test suggested that the distribution feeder was a distribution facility, the commission would say, yes, that's right. The question is the Iron Hill substation a transmission facility, and therefore the cost could be directly assigned to Narragansett, or is it a distribution facility, in which case they couldn't, because that wouldn't be an appropriate transmission charge. So the fact that the distribution feeder is proximate to the to retail facilities means it's a distribution facility, yes, but the Iron Hill substation is not, according to the commission, and therefore that weighs in favor of making it a transmission facility.
I guess what I'm saying is that under this, applying the 7-factor test to the Iron Hill substation requires looking at the purpose and the customers that it serves, which would include looking at issues like whether the power is reconsigned or transported to another market, or whether it's consumed in a comparatively restricted geographical area. And I took Green Development's argument about it being consumed in a relatively constricted geographical area to rely on pointing to the feeder and pointing to the, the whole function of this as a project in the first place.
Well, the whole function of the project is to bring the power out into the transmission system and transmit it to other parts of the Narragansett system. So the commission found that that purpose was a transmission purpose.
Again, then just pointing to the voltage of the H17 line.
Not just to the voltage, but to the fact that all the power goes to the Iron Hill station and onto the transmission system.
But you're characterizing it as a transmission, as going onto the transmission system, and Green Development says, yeah, temporarily, it just is being stepped down, and then it's flowing right back into a distribution feeder.
And somewhere else, yes, on the Narragansett system. Now, or that's far enough away, and here that's what the commission determined.
Any more questions? Mr. Estes, I didn't want to cut into your time, but I wanted to ask you just briefly about FERC's implementation of our Allegheny Defense Project and bank decision a couple of years ago. Mm-hmm. And your attachment B is, and of course, as you know, that's where we threw out the tolling orders.
Yeah.
Okay. Your attachment B, which is the order of April 18th, 2022, denying by operation of law, I guess, the rehearing. But at the same time, the next paragraph says, we reserve, in effect, we reserve the right to revisit this. And you did, FERC did revisit it within, on June, I think it was 16th, within the 60 days that you have before the petitioner, like Green Development, could come before the court
Right.
And my question is, and so I want to ask you if this is the standard operating procedure, because it seems to me that FERC could take longer than the 60 days, but just would run the risk that after the 60 days, a petitioner would come into court and you would lose jurisdiction. Is that your understanding, that you don't have to?
Yes, Your Honor. I think the Allegheny defense decision suggested that the commission could issue an order addressing the merits at any time until the record's filed with the court, at which point the commission loses its jurisdiction. And this court suggested that because the commission said it's frequently difficult to rule on cases in the 30 days it has to issue a ruling. And that's certainly the case. So very frequently, the commission does issue one of these notices that says it intends to rule. Sometimes it issues a notice saying it's denied by operation of law and we don't intend to rule. You can go ahead, but typically we say that we do intend to rule. And sometimes we even ask this court, or whichever court it is, to obey the proceedings so that we have more time before we have to file the record. So that is typically what we do.
And do you get time from the courts?
Usually, not always. And sometimes, the point in Allegheny defense was that the court gets to decide how long we get. With the tolling orders, the commission got to decide how long it had, but under the new regime, the courts get to supervise how much time we take. And typically, if we're not asking for a whole lot of extra time, the court will grant it, but not always.
All right, my question still is, if you waited until after the 60 days, is FERC's position, if the petitioner doesn't go into court and waits on you, thinking, well, we might get the relief here still, it's just going to take more time. Have you done that, or do you stick strictly to that 60 days? No,
we don't stick strictly to the 60 days. And I think there are cases that came out after Allegheny defense that said that if a party waits until after we do rule, even if it's more than 60 days after the notice is denied by operation of law, that the petition is still timely.
And you don't need to respond to this. I still don't know what we accomplished by that opinion, but anyway.
Well,
all right.
I have a couple of questions, if I might, about the tariff points. In Schedule 21 LS, the portion that talks about transmission customers wishing to revise the local service agreement, termination data, or make upgrades, is that FERC's understanding of how the reason that Schedule 21 LS would apply would because this is an upgrade?
That was our reason why we thought that a new request was not required. Is that your question?
Yeah, I just wanted to know, as an expert matter, that this would be an upgrade, and therefore it's not required to execute a new local service agreement.
Right, because it was an upgrade to address changes in the operations of Narragansett, not a new request for service. So the point, I think the Schedule LS21 says that the new request for service is required to facilitate revision of the agreement. But if the revision has nothing to do with providing new service, then a request doesn't facilitate revision.
And that goes back to my other question, which is about the language requesting service. And I mean, one of the rules that we use in interpreting legal text is to give a parallel definition to the same term used in the same provision. And we have requesting a transmission customer requesting service, or a generator owner requesting an interconnection. And FERC reads the first use of requesting to mean it could be in an ongoing way in receiving service. But it's really hard to read the second requesting, a generator owner requesting an interconnection, to also countenance something that's already happened or happening. And so that would seem to me to really support Green Development's view, which is that there has to be a discrete request, and that would at least trigger the possibility of accompanying studies. And it helps to identify the time, the sequence of whose demands are overloading the system.
Well,
Why is that not the right way to read requesting? Or in fact, the only way to read requesting?
Well, I think there are differences between a transmission customer and the generator requesting interconnection, because when you request interconnection, by definition, you're making a request to make a change to the transmission system.
Exactly.
To increase.
Exactly.
And
yet the
once
same word is used, requesting service, indicating the same idea of an incremental new moment rather than.
Well, I think the difference is it's not possible for a generator interconnection to have the same facts that we have here, where it's not, in this case, it wasn't a request for new service. It was just the change in the operations of the customer that caused the need for these facilities. And I think it's important to note that the tariff doesn't refer to a new request for service or a contemporaneous request for service. It just says a transmission customer requesting service. And the fact is that Narragansett has been taking service continuously since it made its request. And in fact, because its customers, it serves retail customers whose loads are constantly changing as they turn the lights on or off, or the air conditioning on and off. Narragansett is continuously revising the amount of service it wants. It's constantly revising up and down the service that it's requesting. So I think it's reasonable in that circumstance to treat them as a requesting customer.
But is it constructing facilities? I mean, that's what this provision is. Is it constructing facilities or portions of facilities in response to, as you say, the up and downs of its service? It seems like, one way to read this, and arguably the most reasonable way to read it, is that when there's that kind of increment that requires the construction of facilities or portions of facilities, that there should be and even though it's incremental, I understand the facts that you've just described, but there should be a distinct service request, because isn't this the provision that triggers or may trigger various studies about, the system impact and the like?
Well, Your Honor, I don't think that's correct, because I'm sorry, I lost my train of thought.
I was just saying that the interrelationship between a request for service and whether there's a application required and potentially a system impact study required.
Your
You
Honor,
need some moment where that comes to FERC's attention and this is analyzed.
I think it's important to realize or to note that the tariff doesn't establish a request for service as a separate requirement to be a direct assignment facility. Requesting service modifies the words transmission customer. So it's really identifying what customers could be subject to having to pay direct assignment costs. So in that context, we're talking about, the question is Narragansett a transmission customer requesting service? And I think it's reasonable to say they are, because they requested service and they consistently take service. They've never stopped. It's not like a situation where you made a request, stopped, and now you need to make another request. It's ongoing. So because it modifies transmission customer and doesn't establish a independent requirement, I think it's reasonable to interpret that as applying to Narragansett in this circumstance.
All right, thank you.
Thank you, Your Honor.
Ms. Almeida?
Good morning, Your Honors. May it please the Court. Marianne Almeida on behalf of Intervenor, New England Power Company, doing business as National Grid. I'm happy to focus my time anywhere where the Court has particular questions. Otherwise, I'd like to start with the jurisdictional argument. And I'd like to first frame the question because it's different than as has been discussed throughout this argument so far. It is atypical for a generation of this magnitude to be connected in the way that this generation was. It is far more common for it to be interconnected directly as a generation facility to the grid itself, rather than through a substation as is set up here. The reason this is important is because only the portion of the facility that is a direct assignment facility under the terms of the tariff is what is actually paid for under the FERC jurisdictional determination here. And that is the portion of the facility that interconnects the H17 line into the Iron Mine Hill Road substation, not the portion of the substation that includes the distribution feeder, the 34.5 kilovolt line. It's only the portion that connects to that transmission line itself.
So is that your answer to double charging, is that there are two different portions of the facility and one of it is considered to be federal jurisdictional and its maintenance and operation is charged under the federal tariff and some other portion of it is considered to be state jurisdictional and charged under the state tariff?
Yes, Your Honor, and only the portion that is under the federal jurisdictional tariff, the H17 transmission interconnection, is the portion that is before the court and that was before FERC originally. The reason that that's important is because that's what the jurisdictional determination must be made based on, not the 34.5 kilovolt feeder, not the portion of the facility that is within the distribution area.
I hadn't really taken the argument to be dividing the facility into parts. And when we look at the facility under the 7-factor test, there's a bunch of factors that just seems like FERC hasn't analyzed. I mean, the proximity to retail customers, the configuration of the facilities. Maybe you can speak to some of the questions that I had earlier about, what is the proximity to retail customers? I thought they were right down the road.
Certainly. So let me first answer the preamble to your question there about the portions of the facilities. Now, the definition of direct assignment facility explicitly recognizes that portions of facilities can be direct.
I understand that, but I just hadn't read your brief or FERC's brief or its order under review as bifurcating this facility and the charges associated.
That's because it's only the portion that is transmission related that is at issue here. And so if I can get to why that portion is transmission related rather than distribution related. I think the factors, while they are a poor fit due to the nature of this project that is being connected, still in their functional and flexible way demonstrate that it is transmission. The most important factor, and to get to your Honor's questions earlier about the 115 kilovolt line, it's not just the magnitude of the voltage there, but it is that line is an existing transmission. ISO New England has treated that line as transmission throughout. And that transmission line needed to be redirected and reconfigured through the new substation to accommodate this. To make that portion of an existing transmission facility considered distribution would be completely inconsistent with how that line has been treated throughout its existence. To the first factor of the proximity of retail customers.
Before you get to the factors, can you just give me, in plain English, if possible, a summary of these two components? There's something called the distribution feeder, which has been held to be distribution and it's not before us. And then there's this other thing that we're talking about. So can you just tell me what those are and how they relate?
Certainly, Your Honor. And there's two configuration diagrams in the JA that I'd like to direct you to. The first is JA 67,
Right.
which was discussed earlier.
Right.
So in the proposed new configuration, in very small font at the bottom, you can see a little squiggly line and it says 33/55.
Can you get a little closer to the microphone?
Let me try that.
All right,
Is that
go
better?
ahead. Can you start again?
My apologies. On JA 67, the bottom configuration, the proposed new configuration, in the Iron Mine Hill substation, that substation in the center of the diagram there's a little squiggly line noted with 33/55.
Right.
That is shorthand for the transformer that exists between the distribution feeder at 34.5 kilovolt and the 115 kilovolt line. So that's where the boundary is between the distribution facilities and the portion of this substation that relates to transmission. The place where it's easier to see this is at JA 494. This is an expanded image of the configuration that is part of the interconnection study that was performed in considering whether the upgrades to the transmission system were necessary here. You can see the same transformer about a third of the way down the page, and it's listed as with the broader terms and explanation that it is the 115 to 34.5 transformer. So that's the distinction between the above that is the.
Sorry, my eyes aren't that good. Where are you?
It's difficult to see. So
Is that labeled number one you're talking about? No.
yes, Judge Hillard, it is labeled number one. That's the transformer.
To the right of what looks like two squiggly lines.
Correct. The squiggly lines is the transformer as represented in this configuration. And beneath that is the 34.5 kilovolt area of the substation. Above that is the 115 kilovolt area of the substation. You can see at the area above the lines of H17 going to West Farnham in one direction and Riverside in the other direction. Those are other substations on the H17 line. And again, that H17 line is the existing transmission line that ISO New England recognizes as a transmission facility.
And am I correct that the power is largely, if not exclusively, in practice? It can flow either, but flowing left to right in terms of if green development is not taking power off, except potentially to run its facility, and it's putting power on and sending it to the right.
Your description of green development's role is correct, but in this configuration, green development is at the bottom of the page.
Right.
The energy
But
flows
still,
up.
West Farnham is up to the left and Riverside is off, right?
That's correct, but the 115 kilovolt line can go either direction.
Can go.
Can go, correct.
Green development's power, though, there's no evidence that does anything other than go one direction.
Which is, on this page is up to the
Up to
transmission
the, and then out Riverside.
out in either direction on the transmission line.
Can go, but does go?
My understanding is that it does go either direction because that line goes both directions. There is nothing though that, or would be unexpected for power to go down the page to green development, which is the way that the factor plays here, is that the power flow goes from green development through the 34.5 kilovolt line in the distribution node onto the transmission line, and then to other distribution loads after flowing onto the transmission line in either direction.
And in terms of proximity to retail customers, it was, FERC just said that it's transported across the system, so we're not really going to look at who actually is ultimately using this power.
So the proximity is measured in terms of purpose, and the purpose is that it goes not to another customer within this distribution node, but to customers on other distribution loads like Riverside or West Farnham or farther away. The Narragansett system covers basically all of
So
that.
is a node the same as a substation? I was not clear about that as a technical matter.
That is my understanding, that the distribution node, as we've used the term here, refers to the substation. I believe you could also refer to a particular area of generation to be a node. But as we have used it in our brief, the distribution level is what we consider to be the node. That means that the proximity of the customers is further away, even if it is not as far away as green development would have it be. The fact that it goes over the transmission system to get to those other customers shows that the purpose is within the transmission grid. We've also talked about factor 3, that the distribution goes out of green development's facilities onto the transmission grid, not the other direction. And of course, factor 7, which gets back to the size of the voltage line, that it exists on a current transmission line regardless.
But the direction of power flows, typically, the FERC has analyzed not just whether power can flow in two directions, but how much power actually flows out relative to how much flows in. So it would seem that the direction of power flows very much favors green development's position.
I disagree, Your Honor, because the purpose of this connection is for the power to flow out.
Right, and that's one direction, not for it to flow back in. So it's not that green development is taking anything off the transmission system. It's really here to put it on, and then you get to factors 4 and 5, which the commission kind of blew off, but I think are central to green development's position, which is that the power, whether the power is distributed to a local distribution system, and technically, of course, it goes onto the 115 system, but it's not transported off to another market. It's consumed in comparatively restricted area, is it not?
Your question, Your Honor, gets again to the distribution feeder, which is not part of the direct assignment facility.
It's not part of the facility, but it's part of the context. And I understand this analysis to look at the context, not just the facility itself. It's looking at retail customers. Those are not part of the facility, right?
Certainly.
And where things are consumed, that's not part of the facility. It's looking at the context.
Right, but it's the context of the facility. And the context of the relevant portion of the facility here is all transmission. It's not what happens beneath the transformer that we've looked at 494. I see my time has elapsed, but I'd like to just briefly address the requesting service question. Substantively, green development would read into the phrase customer requesting service the requirement that does not exist in the definition. And that phrase contains no such requirement by its plain terms that a request be contemporaneous. This compares with what the definition says about specifying the direct assignment facilities in a separate agreement or elsewhere. And the participle phrase at most is temporally ambiguous, to which this court would defer to FERC's determination. If there are no other questions, I thank you.
Mr. Bustami, why don't you take 2 minutes?
Thank you very much. So I first, Your Honors, wanted to address the prior question.
Sorry, what?
I did want to address the prior question regarding where the transmission and distribution are in relation to each other and what green development's contention is here. So I think that counsel for FERC and intervenors explanations actually highlighted many of the issues here. What's happening here is that it's true that the right is a distribution system, but the left side of the schematic, so referring to the 115 kilovolt line, is also a distribution line. So when FERC is saying that this power is being transmitted on the transmission system because it's on a transmission line, FERC is begging the question. It's somewhat circular because the question is that line a transmission line or not? And the problem, I think, as highlighted by FERC counselor, is that FERC is focusing on an assumption that the line is transmission to classify this line as transmission. But really, the focus is on the destination of the power. And I think it's clear from the record below and also the statements of opposing counsel that the end purpose, the destination of the power is retail. So that's the answer to what is on the left of the line.
But isn't the end purpose of all generated power ultimately retail? And the question is about how it's carried there?
The ultimate, Your Honor, no, the ultimate purpose is going to be retail, but what separates is the retail function is going to be whether or not you're doing a wholesale transaction or not. So you have other, like, so theoretically, if power is transmitted in general on the transmission grid, sure, it ultimately gets to retail, but it first goes to somewhere else.
But isn't that just as circular as what you've just accused FERC of doing? It's saying, we didn't intend this to go to wholesale, even though it's going to Narragansett, and Narragansett is somewhat treating it as wholesale by putting it on this interconnector? No?
No, Your Honor, because what I'm focusing on here is who's going to be the first person in line to purchase that power. So the first person in line to purchase the power here is going to be the distribution customer. Mm-hmm. In the wholesale context, the first person to purchase the line is going to be the utility like
Not the line, the power.
The power, excuse me. The purchase of the power is going to be the utility like Narragansett.
Let me just back up on the direct assignment facilities definition and the requesting power. If you were right about that, what happens after remand? Would Narragansett submit an application for service and do any missing studies, and then go ahead and charge the direct assignment facilities charge, or is it too late for that to happen? Is that why that's an advantageous position for you?
No, Your Honor, it's not too late for that to happen. We hope that that the orders will be vacated and remanded, and that on remand, we will see FERC require a transmission application so that green development can and other rate-paying customers can also have a chance to evaluate why these upgrades are needed. So I think, if I may, Your Honor, address another point from the Intervenor Council. And I know that there was some discussion about, this idea that, could you split up the facility and charge some for transmission, some for distribution? We just want to point out that all of these, facilities are being included, including the theoretical transmission side is being included over here. So that's why there's a duplicative issue, because we're already, so even in theoretically speaking, you could split it up. It doesn't solve the duplication issue. So
because they're not splitting up.
Because they're not splitting up, exactly.
And what is the Rhode Island proceeding that council pointed to the correct place for you to raise that?
No, Your Honor. So in terms of the splitting up of the facilities,
Yes, avoiding duplicative costs.
That would not be the correct place to address whether there are transmission charges that are being assessed that are duplicative with the state jurisdictional charges, because the Rhode Island Commission is not going to look at whether or not these are actually legitimate transmission charges. They're just going to defer to whatever FERC thinks. So that's part of the issue over here. The charges are essentially just being passed through. Narragansett and New England Power were affiliates at the time. So the pass-through is just automatic.
So FERC is saying what happens in Rhode Island is not our problem. Rhode Island will say, as you anticipate, what happens with FERC is not our problem, and nobody's going to examine the potential overlap.
That's correct. That's precisely how we wound up in this problem. Everybody's pointing fingers to the other person.
Isn't it really how you wound up in this problem, that you entered into an agreement with a very big term that was as not yet pinned down and started building the facility without?
No, Your Honors, because when you're talking the agreement, I presume that you're talking about is a distribution interconnection service agreement. And so when you're looking at the various provisions of that, but what you're really looking for is that these are essentially placeholders for charges to be passed through and assessed on the customer. But that's assuming that the charges are in fact legitimate on FERC's end. So if the charges aren't legitimate, then it essentially voids that provision ab initio, because you have a situation where the charges aren't being assessed. So theoretically, the interconnection agreement permits green development to be assessed these transmission charges as a pass-through, but if there's zero charges, then there's no pass-through.
All right, thank you.
Your Honor, may I conclude in requesting the court vacate and remand on arbitrary capricious grounds? Thank you.
Thank you.
Case number 22-1763, American Society for Testing and Materials et al. Appellants versus publicresource.org, Inc. Mr. Klaus for the appellants, Ms. McSherry for the appellee.
Good morning.
Thank you, Judge Henderson. Good morning. May it please the court. The district court's order permits public resource to engage in the essentially verbatim copying and unlimited internet distribution of more than 200 different works that plaintiffs properly copyrighted and that Congress, governmental agencies, and private parties alike relied on and encouraged to promote public safety, save the government and taxpayers from having to bear the costs of development, and support the efficient operation of wide swaths of the economy. The district court reached that sweeping result as to 185 different works by systematically misapplying the clear guidance and specific instructions that this court provided when it remanded for reconsideration of public resources affirmative defense of fair use. As to the 32 works where the district court held public resources use was not fair, the district court abused its discretion by declining to enjoin public resource based on the speculative possibility that one or more of the works might one day be incorporated by reference. It was error to grant public resources summary judgment motion and not to enjoin it. The district court's order invites public resource and anyone similarly situated to it to copy and distribute any IDR work without limitation. No copyright owner could long survive the unrestricted and widespread copying of the type public resources engaged in, but that is where the district court's order leaves it. And, Your Honor, there's been a substantial amount of briefing and paper in this case, I know. I would propose to focus on 3 areas, although obviously subject to the court's questions. First involves the first 3 fair use factors as set forth in this court's, what we call the ASTM 2 decision. And then I'd like to spend some time on the 4th factor, or market harm, and then to talk about public resources alternative argument or affirmance based on Georgia versus public resource, which we think is inapplicable by its terms. So to start, Your Honors, with respect to the first 3 fair use factors, this court remanded to the district court with quite specific instructions, a quite detailed set of issues that the district court was to consider as to each of the standards. And the court made it clear to be a standard by standard evaluation of the particular legal status and to weigh the factors as PRO's use as applied to each. And with
District Court
respect
went standard by standard in excruciating detail.
Judge Katsas, the district court did go standard by standard, and the appendix is quite lengthy. I agree with that. But what the district court did not do was to grapple with the specific instructions that the court gave as to each of the first 3 fair use factors. For each of these paragraphs in the appendix,
Well, the first thing the district court did, tell me if you disagree with this, but she solved the problem of copying standards or portions of standards that hadn't been incorporated into law, right? You won on 32 of those and half.
there was a grouping at the end of the so-called categories reward.
So really what we're talking about is the non-commercial dissemination of standards that have been incorporated into law.
That have the standards, so Judge Katsas, the standards have been incorporated, but whether the standards actually in total impose binding legal obligations, which is the question
Right, so-
that the court, I apologize.
No, go ahead.
Is the question that the court asked the district court to consider. And essentially
I mean, maybe yes, we flagged that as a relevant consideration for fair use. But we didn't really say that background material or safe harbor provisions could not be fair use.
That is correct. But what the court did say was that the justification for the copy might be quite different where what you have was something that did not impose a binding legal obligation. And what Public Resource did, I don't have a copy of one of the standards of it, but if you'll forgive me for using this as an example, they essentially copied and posted everything cover to cover. And
everything that had been incorporated.
well, that's it. That is actually, we actually dispute that with respect to a number of the standards, Your Honor, because we think that the incorporation with respect to some of these standards did not incorporate the entire document. Let me give you an example. So Public Resource says at page 6 of the red brief, they say when Congress or when an agency wants to incorporate the entire standard, it just doesn't say anything. When it wants to incorporate a specific portion, incorporates a specific portion. And they give as the example a regulation from the Pipeline and Hazardous Materials Safety Administration, 49 CFR 192.7. And in the joint appendix, the statement of facts, what Public Resource said is, if you thread through that, what it says is NFPA 70, 2008. We're done. Congratulations, you've found a standard that's been incorporated in full. But in fact, when you read through what 49 CFR 192.7 subsection 4 actually says is that the National Electrical Code is IDR approved for 2 further subsections. And when you go to those further subsections, one of them says 192.163E, says electrical facilities, electrical equipment and wiring installed in compressor stations must conform to NFPA 70 so far as that code is applicable. And we know that there are huge portions of the NFPA 70 of the National Electrical Code that couldn't possibly apply to a compressor station. There are entire sections of that standard that deal with things like carnivals, circuses, fairs, that deal with motion picture and television studios and special wiring issues for those. And so, Judge Katsas, that's to the point that we submit that when an agency has simply said, we incorporate this standard for these purposes. Take the Life Safety Code example that we gave, which applies the Veterans Affairs regulation for veteran cemeteries, where the underlying code has provisions that deal with 1- and 2-story family dwellings and daycare centers. It can't possibly be the case that what the agency is saying is, well, we've incorporated that. It's kaboom. We're just going to, everybody in the world should assume that the entire document, cover to cover, has been incorporated by law.
So, go ahead. Suppose it's crystal clear. The incorporating statute identifies with precision the private standard incorporated.
Yes.
Right, ASHRAE 100.2 or whatever it is. And then you look at that provision, and let's say it just conceptually has 3 different parts. One is the directly binding legal text, right? What we said would be essential to understanding legal obligations, right. Okay? That's the first category. Second category is a safe harbor provision, right? It says if you do the following, you will be in compliance with the standard, okay? Maybe less essential, but it's a safe harbor.
Yes.
And the third category is explanatory material. It has the private standard has findings. It has a statement of purpose. I had thought this whole dispute is about those second and third categories, and you say those can't fairly be copied.
The dispute,
Is that fair?
if I understand your question.
Just as a conceptual.
I think conceptually, the answer is yes. It is with respect to, in the type of circumstance, with the type of IDR regulation that you described, it is with respect to the other two categories.
And wouldn't someone trying to figure out his or her legal obligations want to know all three categories?
They potentially would want to know the second category. I grant that on the question, although that is, as the point that this court made was that with respect to something like a safe harbor or a reference procedure, that something like a paraphrase might be more adequate. And that's one of the many showings that we made in the district court in terms of taking the court's opinion and trying to apply it to the record, was to show that it was not necessary for there to be 100% verbatim copying. And then when you move...
Mr. Claus, let me just, oh, I'm sorry, finish your sentence.
I was just going to, thank you, Judge Poyer. I was just going to say, Judge Katsas, with respect to the third category, we think that it moves even farther afield in terms of what some of the, and the other point that I would make, and it's a point that this court emphasized over and over again 5 years ago, is that not all of these are created equal. And so what you have described as being in bucket 3, Judge Katsas, as informational material.
Right.
There's a wide variety of that type of informational material. Again, we did the work in the district court of trying to explain what, how to separate, how to separate these matters. And what we're instead told by public resource, and it does appear that the district court accepted it, is as long as you can find an incorporated regulation that doesn't specifically carve out a particular section, then you are essentially, if you're home free on the first 3 fair use factors.
Now, what about who is you and for what purpose? I understand the problem, I believe, from SDO's perspective, which is if incorporation by reference is used, let's just say sort of broadly or sloppily, I'm going to refer to the whole, fire standards, and everyone who looks at them is going to know, that they're supposed to go to the wood structures thing. But so I don't even, as the lawmaker incorporating by reference, I don't have the incentive to be very precise about it. Your problem is then, and then public resource is just looking at what the lawmaker said, because public resource is not, a highly trained lawyer who's going to go through and carve out, and edit away the non-necessary portion. They're just going to put up what the incorporation by reference refers to. But the problem from your client's perspective is when it's done in that sort of wholesale way, then you end up with someone who might want to, publish things that your clients want to publish, and that is their work, and send it off, and it becomes a substitute even in the industry setting where, electricians want to be doing things in a uniform way, and fire safety professionals want to be doing something in a uniform way. And so they're referring to these in a context that is distinct from the context of legally binding standards. Like that, is that a fair description of sort of the...
That is a completely fair description, yes.
Okay, but I've also flagged the difficulty of requiring somebody in the position of public resources to make the more fine-grained division. But so if it were possible in the real world to say fair use applies to, accept what the district court did in terms of applying the fair use analysis to what the lawmaking authority referenced, and only that, right? And if we then were to apply the fair use defense only to uses of those standards qua law, when used as law, and say the fair use defense does not apply when enterprising publisher wants to scoop the fire codes and sell them at undersell the owners of the work, that even though they found it on public resource, it is not fair use when it's not being used, sold, profited from in its role as law. I mean, it's conceptually that's sort of, I'm wondering if that were a distinction that could be maintained, would it be is that acceptable to you?
It is. I think I understand the question, Judge Pillard, and it would not be acceptable for the following reasons. One is that what public resource puts up is a verbatim copying of what we've got. We've stipulated that. And there is no limitation on the distribution of it. And to the point that well, what about the people in the world who would need to see, maybe there is someone, although there is no record evidence of it. There's been 10 years of litigation, and we have not had anyone come in and say, I wanted to debate one of these standards. I wanted to propose something. We don't have any of that. But if there were someone who said, I really need to have this, all of the standards, every one of them, cover to cover, is made available by the plaintiffs through their.
I think you lost that argument on the first appeal. Is that not right? I mean, if that were enough, then the prior panel wouldn't have rendered the decision that it rendered.
It would. In this respect, I don't think that it's settled by the former appeal, Your Honor, which is that there has to be an evaluation of what it is that the defendant here is doing, but the effect, as you pointed out, the substitutional effect on the plaintiff's market is. And the fact that, and we think that it is relevant to the consideration, both to the degree of transformativeness and to the question of the substitution.
But is it a conceptual problem or a practical problem if public resource website were, directed that it's to be used only to analyze or critique or refer to the materials insofar as they've been IBR'd? Isn't that an adequate limitation?
That if there were a way to keep the genie, as it were, in the bottle, that would be a very different case, Judge Pillard, and I think that it would be much harder.
Why is there not a way to keep the genie in the bottle? I mean, why is that not the situation we face here?
Oh, there are a couple of ways. There are a couple of ways for public resource to do some things. For example, we had evidence in the record that the Internet Archive, which is where they post all of their material, that they have a borrowing or a checkout function. And so someone, unlike a Napster for the standards world type situation where anybody can go and take something down, that there is a function where you can put a checkout on. The book is taken out, and the book is taken back. Similarly, with respect to the sight impaired, there is a function on Internet Archive that provides for encrypted copying for encrypted copies, and that they will only be used by persons who have sight impairment. There are those mechanisms were available, and public resource doesn't use them. So I would agree with you, Judge Pillard. It would be a much closer, a much different case if what we had in the sense was public resource operating speaker's corner, and nobody could take the standards with them when they left speaker's corner after listening to them explain. Or somebody who wanted to research them could go out and do that in some way. But again, that's not the situation that we have with respect to the defendant's use.
Right. Well, they want to be able to make it easy for people, have free access. And I take it the problem is if they really were using it only for legal analysis, legal, compliance, that could be on the fair use side. The difficulty is in the implementation of that line. What if you found that, do you understand anything about the first panel's decision to prevent you from pursuing someone who did what I was referring to before? Downloaded the full fire code because it's been IVR'd in full, bound it up into a book and sold it in competition with your client to, firefighting professionals who are not worried about complying with the law. They're worried about, or construction professionals who are worried about, making good buildings that aren't going to burn too easily. That you could still pursue that as not fair use under the ruling of the first panel?
Well, unfortunately, Judge Millard, the way that the internet works, we had evidence that we submitted, is that the people who can download these we don't have any record of who they are. Very deliberately, public resource does not keep track of who downloads their works. And so we don't know, for example, who the people are who, with respect to the 2017 version of the National Electrical Code, have downloaded that work or accessed that work, could either be to view or to download, something like 40,000 times. We don't have a record of it, and we do see, as we put into the records, evidence of some people actually reselling things on a site like Scrib. And part of the lesson, frankly, not just from this case, but from 20 plus years of cases involving distribution of copyrighted works on the internet, is that you don't want it, is that it's unfair to put the copyright owner into having to play a game of whack-a-mole.
I have a much more specific question for you, which is, if we were to agree with you that the district court misstated the burden on market harm,
Yes.
can you spell out how, if at all, it affected the summary judgment determination? And in particular, is there any way that your clients relied on what you say is the appropriate burden allocation to somehow hold back on developing or presenting evidence of market harm?
We did not. So we did not hold back on developing evidence of market harm. That said, Judge Miller, we think that it's clear that it was the allocation of the burden was wrong, as we've said. And we also think that regardless of who has the burden or where it was, at a minimum, we presented a triable question of market harm.
So you're saying just looking, bracketing the burden question on the record, you've made a case that prevents summary judgment.
On the record. And I'll just pick up on the point that I was just describing to Your Honor, Judge Clark, where I said that there were these copies that we know are public resource copies, because when you go to the Scrib website, what it shows you is the first page. And the first page is not yet what the title of the ASTM standard. The first page is public resources, stars and stripes and all that page. And it's there. And what the district judge said about that at page 32 of the memorandum was that there was no causal connection between public resources distribution and these third-party sales. And there were numerous other pieces of evidence that we had, Your Honor, that we think clearly add up to, at a minimum, again, a triable question of fact on market harm.
finished on that. So two quick questions. One is, in the government edicts context, the Chief Justice expressed concern with having a dual system where some people have the coach version of the law and others have the first class version of the law. And that was in the context where the coach version was everything with the force and effect of law, and the first class version was the annotations which under Georgia law had no force and effect of law. Isn't that concern present here and even greater, because my categories 2 and 3 are materials which have the force and effect of law. So the coach version is you just get the directly controlling text, and the first class version is you get the safe harbors and the explanatory material.
I completely understand the point, Judge Katsas, and I would say no, because I think the interests on the other side are different. The interest of the Chief Justice was responding to was a series of arguments that Georgia made for saying, as you had pointed out, that the line should be drawn at what has the force of law. And I think what that said is there's no need to get into that here, because we have the straightforward authorship, and it would cause a lot of difficulties. Whereas I think the interests in this case are different because the standards are privately authored, and
I guess I would just quibble just a little bit, saying the interest of the public in knowing the law are the same, but you might have more on the opposite side of the balance.
Well, except for the fact, Your Honor, that we made all of the standards available online. That's one thing. And the second thing is that you have a multi-decade process of, frankly, of the political branches of the Congress, of the administrative agencies, considering the argument and balancing the question, which really what this comes down to, Judge Katsas, is a balance between providing the incentive for this, what no one denies is incredibly important work to be done, and providing access, which is done through the reasonable availability standard.
Last one for me, which is you have flagged what seems to be a problem of, I'll just call it overbroad IPR. And the case that sticks in my mind is the regulator wants to address treating veterans cemeteries, and they incorporate, whatever.
Life Safety Code 101.
The question is, would you be able, the standard has to be formally incorporated through notice and comment rulemaking. And you've cited a lot of authority suggesting Congress wants the copyright to be respected somewhat. So in a case like that, I assume your clients could come into the IBR rulemaking and argue that the proposed incorporation is arbitrary and capricious because it's overbroad. Is there any reason why you couldn't do that?
Well, I guess a couple of reasons. One is our having notice of it. And while that is essentially I don't know what the manageability of that would be at the federal level, just in my response to it, Judge Katsas. We also face the problem that it occurs at the state and local level as well. And the idea of putting the burden on to the standards development organization to essentially have, a radar on what can be done in any jurisdiction, we think is too much burden.
Is there any mechanism to make that argument later? I don't know, petition for unincorporating. I probably face a pretty tough stand.
I would, off the top of my head, Your Honor, I don't know the answer. And again, I do And I also think
I take your point about notice. Thank you.
Thank you. Your Honor, I'm substantially over my time. I'm happy to, if the court has other questions.
We'll give you a couple of minutes in reply.
Thank you. And also, Your Honors, Mr. Fee, who represents ASTM, is here and was available if the court had any ASTM specific questions. But if not, I'll just come back for both.
Thank you.
Thank you, Your Honor.
Ms. McSherry?
Can you hear me? Is it good? All right. Thank you. Excuse me. Good morning. May it please the court. As has been mentioned a few times, this is our second roundup here, but the core question has not changed. And the core question is, can my client, public resource, an entirely non-commercial entity, provide the public? And by the public, I mean citizens, I mean advocates, I mean journalists, and even courts, with unfettered access to the law? And the answer to that question is still yes. Whether it's a tax code or the building code, public should be able to fully access, explore, comprehend, and teach the law.
The last time around, I thought there was a pretty straightforward question, which with a pretty straightforward answer, but Judge Tatel's opinion for the court was a lot more complicated.
Well, I still think it actually boils down to a pretty straightforward question that was an answer that was reflected in how the district court interpreted ASTM2 and applied it.
I mean, he was very specific in saying that IBR can have different consequences. And he did seem to distinguish the three categories I laid out, right? The directly binding legal text is different from the safe harbors and the explanatory material.
So the opinion does draw some distinctions there. It never draws a categorical distinction to suggest that it creates a spectrum. But as we interpreted it, and I think as the district court interpreted it, when you're trying to look for what is a binding obligation in this context, it's fair to look to the incorporating language. And if you think about it as a practical matter, that's because that's what normal people would look to. You look to the APA and the CFR lay out how to go about incorporating by reference, and agencies then follow that procedure. When they follow that procedure, they've created a binding legal obligation, and putting people like my clients or anybody else in the position of having to second guess that decision creates just a morass.
That makes a lot of sense to me, but it also, the opposing counsel's argument also makes a lot of sense that the authority, the government officials that are incorporating by reference don't really have an incentive to slice this as finely as perhaps they should. What's your response to that? I mean, you have to appreciate that in your mission, which I understand to be about the law, it is only a subset of materials that the development and use of which is within their mission, which is, much more generally coming up with useful standards that are, many of which may never touch law, that have to do with uniformity across industries and jurisdictions and best practices. So if the posting ends up needlessly, because of sloppiness on the part of the incorporators by reference, needlessly impinging on their distinct project, what's your response to sort of how that should be dealt with, other than as they propose, which is that PRO go through and distinguish between necessary and binding and other?
And one of the other reasons that pure public research doesn't do that is we look to the
I understand that. You look at what the legal authorities themselves have specified, and you don't second guess that.
And also what people such as the administrator of the National Institute of Standards and Technology, how they approach it, how they think about it. We think that ordinary people are entitled to rely on how government agencies think about it. but to get back to your question, so again, we only post the standards organizations post, right, and create many, many thousands of standards. We only post what has been specifically incorporated by reference into law via notice and comment proceeding in the context where Congress has delegated to regulators lawmaking authority. So that's the small universe of what we look to. Usually, I think all of the standards in this case have been superseded already. They're no longer standards as standards. They're updated versions, and that's really what the organizations focus on. But we focus on the subset. The second thing, though, is standards.
Just a little question
yes.
for information. Maybe this is really for the other side, but I forgot to ask. Is it not common to incorporate in what one might call a dynamic way, sort of say the latest version of, ASTM such and such?
No, usually you incorporate a very specific version, and that might be updated over time, but often there's a lag between an update and the incorporation process.
Yep, got it.
And so two more points directly to your question. One is that regulators are capable of identifying when they only mean a specific section.
They're capable, but they don't always do it.
They don't always do it, but they do it. So it's not like they don't know how. They do know how. And that is what they're supposed to do. So I'm sorry if they don't always do that, but it's difficult for an ordinary citizen to know, because I can guess the mind of the regulator. And the second thing is, I think that we know that standards organizations work very closely with government. In fact, like the notion of surprise, particularly incorporated into federal law, it strikes me as disingenuous at best. So there's evidence in the record that, for example, ASTM is very proud that 93% of its committees have participation of government employees. There's really some agencies that are actually mandated to work with the private organizations in the development of these standards. So I think the idea that there might be a surprise is unlikely, and so really not a genuine worry.
I have a specific question for you about the market harm factor. Before the district court, you argued that the plaintiffs bore the burden of proving market harm, and the district court followed your suggestion to announce that when a defendant uses the copyrighted work for a non-commercial purpose, the court has placed the burden on the plaintiff to show by preponderance of the evidence that some meaningful likelihood of future harm exists. They're quoting Sony. If we were to disagree, after all, ordinarily the burden is on defendants to establish an affirmative defense, and some of the circuits have been explicit that the defendant bears the burden of establishing a lack of market harm. So, if we wanted to avoid a circuit split, how and could we affirm what the district court did here in view of, by assuming, we haven't decided this issue, but assuming we were to decide that that was an error of law, could we still affirm?
Yes. So for two reasons. One is I would just point out that two other circuits have said.
I understand we do.
So I suppose we already have.
I'm sorry, two other circuits you say have said that it's the plaintiff's burden, although is that...
Well, sorry, just to be clear, what Sony stands for is not an entire shift burden. What Sony says is when a use is entirely non-commercial, like the one here, the plaintiff should be able to come forward with some evidence, not entirely shifting the burden, but rather they should be able to come forward with some evidence. And the plaintiffs were not able to do that. But also, even that aside, even if we disregard Sony, we met our burden. As best you can prove a negative, we came to court, we submitted evidence of testimony from their own executives saying we actually can't track any real evidence of harm. Their own expert simply relied on the self-serving statements of their executives. So we also showed, just one more point, that we also showed that with respect to ASTM, their sales were up. With respect to NFPA, their sales have been they said they're cyclical, and they were falling as of 2006, which is long before Public Resource was doing anything. So we brought evidence to the table.
You say they were unable to come up with some evidence. They point in their reply brief to the drop in NFPA's publication sales, and they point to 42,000 downloads of reposted works following this court's 2018 opinion, in this case, vacating the injunction. So they're pointing to some pretty specific things that they've calibrated kind of date-wise to to the availability of duplicate or similar versions, how do you respond to that? I mean, why doesn't that create a triable issue?
So two reasons. One is that I think that they provided some evidence, and I think that the district court reviewed it carefully and said this is just inadequate. And I think, frankly, she was a little disappointed that this far into the litigation, the plaintiffs, who have unlimited access to their own market data, couldn't provide some more empirical, quantifiable evidence than they did. So I think that's part of what happened. The other thing is I would just point out, this is a fair use case. It's also a copyrightability case, but we'll see if we get to that. But on fair use, you don't just look at one factor. You look at all four factors and consider it in light of the purposes of copyright. And secondly, with respect to market harm in particular, the Supreme Court has told us that when you think about the market harm, you don't just look at numbers, so that's important, but you also have to look at the public interest and weigh it against the need for copyright incentives. And one of the things we know from the VEC court, and we've also heard it from scholars since, is that if there were ever an area where there was less of a need for copyright incentives, it's this one. These standards are created in terms of the actual work done by volunteers who are just excited about making good practice, best practices for their industry. Government employees get in the mix. Lots and lots of people come together. None of those people are doing the work because they're looking for royalties.
But, I gather, and you don't question, that the institutional infrastructure to bring those people together and to track their work and to publish its product. I mean, there is an institution here. You can't say that it isn't expensive, for example, to run a university, even though, the faculty are, I mean, it's not just faculty salaries. And so when these folks are coming together and aren't being paid, there's still a lot of sources necessitated.
Well, that's correct. But there I would point out that one of the things you have to think about in a copyright case when you're thinking about market harm is you have to think about copyright harm. And we know, going all the way back to Feist, that simply investing labor as opposed to creativity does not a copyright make. Again, I'm in no way discounting the value of the work. I am simply saying that I think part of the calculus has to be how much is a copyright, when most of the people who are doing the actual creative work here are people who are volunteers. I have a couple other points to make if I might, but I don't want to make sure I answer everyone's questions. Okay, so I just want to say that I do think that the the district court, I think really actually did look at every standard individually as she was supposed to do. She thought carefully, as this court said, about the legal status of the works by looking at the incorporating language, which we provided to her. And, excuse me, but she was also prepared to consider what would be necessary to comprehending a legal duty, which this court also allowed for. And I think after Georgia, at least we know that is a good, appropriate for a court to do. And that's what she did. And so, she looked at all four factors together rather than applying them in a mechanical way, which is what she was supposed to do. So I think on balance, this is really one of excellent fair use analysis as these things go, particularly when you've got 200 standards to look at. And with respect to some of them, she said not fair use, right? She went the other way.
She went standard by standard. Mm-hmm. And distinguished among them in various ways. And she was very careful to figure out what was or wasn't incorporated. Mm-hmm. But at the end of the day, she applied a per se rule that whatever was IBR'd can be copied.
I think she applied a bright line rule that looked to what is legal. At least by your client who is doing this for non-commercial purposes. Correct, exactly. I mean, there is a whole other context of the other factors, but I think she did apply the rule of what is a binding regulation and what is not. And the APA.
Yes, but binding understood in its broad sense of what was incorporated into law, as opposed to the narrow sense of what is the precise operative text that establishes the obligation.
Well, actually, I think, Your Honor, that she applied not just what was binding, but also what would be necessary to comprehend what was binding. But actually, she really, you can go back to when a regulator in an agency issues a regulation pursuant to the APA, follows all the rules, that whole thing, pursuant to its lawmaking authority, that's law.
That makes
So
a
you
lot of,
really have to
that
second guess
makes a
that.
lot of sense to me. I guess it's just an open question whether it's consistent with the panel opinion last time around.
Yeah, I think it has to be. Well, I think it is, of course I do. But also because remember, the panel opinion said there's a spectrum here. It's not, and allowed for some flexibility. It actually didn't itself assign such a bright line goal.
What do you,
Go ahead, I didn't mean to.
one more. What do you do with this phenomenon that I described as overbroad incorporation? The regulator wants to get at the cemeteries and ends up incorporating something about apartment buildings.
Well, I think that,
They just out of luck.
well, I think what happens in advance is SDOs probably normally would work a lot more closely with the regulator to prevent that. And I think going forward, they're concerned about it. They can do that even more aggressively. We know they communicate with regulators all the time. So that is something that can be addressed. But I think most importantly, again, for purposes of this case, is a tiny little nonprofit in Mill Valley can't possibly have to be in the position of trying to figure that out in advance. When again, it's trying to actually do something I think we can all agree is pretty laudable and important and beneficial to the public interest. And related to that, I just want to have one more note on the reading rooms, because I think it's important that the reading rooms provide very limited accessibility. Public resource does something very, very different. Thinks of itself as a repository, not a gatekeeper. But you don't have to give public resource your home address and sign up for spam. And you can link, you can search, you can cross-reference. And we've got evidence from multiple amici saying this would be really valuable. We would like this. Sonoma County would like to be able to have a integrated code so that people could really understand all the different codes that affect their conduct. Copyright's standing in the way of that right now. That I think is not good for the public.
You haven't mentioned your government edicts doctrine. You opened your brief with it.
Mm-hmm.
If you were correct that it applied, wouldn't that remove copyright protection more categorically than the district court judgment did here?
Well, our argument is that, and this was kept open in the first opinion, is our argument is that if the court decides that we haven't met fair use with respect to any standard at issue before the court, then it would be wise at this point to reach the copyrightability question and basically save other people from having to roll the dice on a fair use defense, as Justice Roberts put it in the first case. In Georgia, and it also feeds back into the fair use argument, because one of the themes of that case, of that opinion, is the animating principle behind all of this should be that no one owns the law, and that was the animating principle behind Georgia. Now, I will admit that applying Georgia here requires a bit of an extension, but not much of one. Again, because as I've said, when a regulator uses its lawful authority to issue a binding regulation, it's creating law in the same way. And when it incorporates other texts into it, incorporating means making part of the law.
So you sort of see that's a little bit how I understand the en banc court in Veek. I think they made a fair use holding, but they were adverting to the government edicts kind of ethos in so doing.
Correct. And so have two district courts.
So you don't think that the government edicts doctrine would yield a broader ruling than what the district court made under fair use?
So I think what the government edicts doctrine does is it's an alternative path of affirming the judgment below. And that's really the question, is the court is supposed to look to the judgment, not just the reason. So this is an alternative reason to affirm that judgment.
If we rest on copyrightability, the incorporation would vitiate the copyright as to everybody. You could have a commercial competitor coming in, selling stuff.
Well, then I think you'd have questions about how that commercial competitor was operating, what they were doing with it. And I also don't think that's very likely.
If the incorporated material loses its copyright protection upon incorporation, none of that matter. I mean, one major part of the analysis here is the non-commercial nature of your client's particular use.
But
You can't account for that under copyrightability.
right. So what I think would happen is not, well, I just don't think that would happen because standards organizations don't operate that way. They compete actually for.
No, but I mean, but your answer to Judge Pillard's question has to be yes.
And if it is, I mean, I think that Judge Katsas is entirely right, that it does yield a broader, it would remove copyright protection more broadly. And then I wonder, since you didn't cross appeal, if that's even before us. Because it isn't an alternative route to defending the judgment. I think it would yield a much broader judgment.
I think you'd still end up in the same place with respect to the 182 standards that are obsolete as a matter of law, because that's only what's at issue here. It's just these standards.
I know, but it's the nature of these standards. I mean, I gather under the district court's holding that they still have copyright protection with respect to other non-law, as law uses, right?
Well, I think under the fair use approach, that would be correct. I mean, it's one of the things we said.
That's what I'm saying. So it's a very different judgment if it's under government edicts, because as Judge Katsas was just saying, that would vitiate the copyright plume altogether.
So another way of thinking about this is that what happens when a work is incorporated into law is that essentially you have now a branch. You have
a different work. You have the private version of the work, and then you have the government edict version of the work. So that's you would basically say, no, this actually the result under government edicts would track the result under fair use. It would just be a different analysis to get a more direct route to get there.
Correct.
All right.
Exactly.
All right. There are no more questions. Thank you.
Thank you.
Mr. Klaus, why don't you take 2 minutes?
Thank you. Just a few very brief points. One is the suggestion was made that there's not reason to worry about commercial competitors in this space. As we pointed out in our papers, my client, the NFPA, is already engaged in litigation in California against a commercial competitor that is doing what Public Resource is doing and is trying to claim the benefit of the fair use defense and making the copyrightability arguments. So they are out there. There was a suggestion that was made by Public Resources Council that there is coziness between the SDOs and the administrative agencies. I think there was a suggestion that ASTM people are in Washington boasting about their relationship with the government agencies, and so there's nothing to worry about their ability to monitor what's going on and what's being IVR'd. There's no evidence of that. The actual record evidence that's in the case is from Mr. Thomas's declaration, which is at page 699 of the joint appendix, which is that ASTM does not lobby for its standards to be IVR'd. There was also a lot of discussion about market harm and the claim that there was nothing that we essentially had nothing. We had a substantial amount of evidence that you had pointed out, Judge Pillard. The other thing that I would say, 2 points, that the standard for harm is whether not just what Public Resource is doing would cause harm, but whether if everybody was doing this in a widespread, unrestricted way. And the last point I'll make is that the standards were down from Public Resource, not just during the time period that the injunction was in effect, but they actually took them down in November of 2015. And since the time that the injunction was vacated by this court, Public Resources posted just one standard, the 2017 version of the National Electrical Code. And so we don't actually have a real-time example of what would happen if they had put the 2020 or 23 national electrical codes online as well. We don't know. And so in some respects, the reason that the evidence of harm and calculating specific harm has been difficult is because of choices that public resources make.
But they're reflecting choices of legislators, and one of the points that they make is that typically legislators are a couple steps behind your clients in that they do incorporate by reference particular date-issued standards, and as your clients are constantly working to improve the substitutability of what's incorporated by reference, it quickly is sort of diminished, given that you're on the edge of progress and the legislators are always a couple steps behind.
They maybe I understand the point, Judge Floyd. The only thing I would say is that with respect to what has actually been posted hours and showing market harm, I don't think that, I think that one needs to consider that there are huge numbers of standards that our clients develop that have been IDR'd from the time the injunction was lifted, but they have not been put back up. So what we've got is a record that is based on some of the...
A little bit of a pause.
Yes.
Let me ask you about that. You mentioned do you have a sense of the proportion of the work of these three SDOs that is and is not IBR'd under the district court's definition, where if a standard in full is referenced, even if, you would say that some smaller portion of it should be fair use. But if, in terms of the unit size that the lawmakers reference, what proportion of your clients' works in total is IBR'd?
I do not have that information at the top of mind for my client. Would it, Mr. Fee may for ASTM. ASHRAE has the standard number is 90.1. That is a much smaller number of works. What I would say, Judge Pillard, is that the works that are at issue here account for an outsized huge portion of the revenue. That publication revenue is responsible for most of the activities. And I see Mr. Fee, Judge Pillard, Mr. Fee may have a more specific answer on AS.
Yeah.
Your Honor, I do know the answer to your question with respect to ASTM. Approximately 10% of ASTM standards are incorporated by reference into federal regulations, and that's at JA 699 of the Joint Appendix.
JA 699?
Yes, Your Honor.
Thank you.
Is there anything else for Mr. Klaus?
Pardon?
Is there anything else for Mr. Klaus?
All right, any more questions? No. Thank you.
Thank you, Your Honor, very much.